Good morning, and thank you, Women Entrepreneurs India, for giving me this kind of opportunity. My name is Prateek Shrivastava, and I am a practicing patent attorney with 10 years of experience in the protection and enforcement of intellectual property rights. So, during this event, I have been asked to provide my insights on the protection of intellectual property rights. So, when you use the word intellectual property rights, the most common word which we see is the word property. So, when we use the word property, that means we have control over something, a control to initiate a transaction. Now, for example, if you own a property, let's say, for example, if you have a land and you own that land, so now you have certain rights associated with that property. That is, if you own a land, you can commercialize it, you can sell it, you can lease it, you can do whatever you want with that land, right? So, but there is another form of property, that is the intangible form. For example, the property which do not have any physical existence. Now, for example, your ideas, your innovations, your artistic creations, your shares, your mutual funds, all these are intangible, but they have a value. They have certain rights associated with that property. So, intellectual property right is basically a concept coming from the intangible form of property. So, in India, we have a dedicated mechanism to protect intellectual property rights. For the innovation side, we have patents. For brand protection, we have trademarks. For artistic creations, we have copyrights. And for your agriculture related protection, we have Protection of Plant Varieties Act 2001, and we have some other protections as well. But in more or less in India, we have seven IPs, and this intellectual property is administered by the Indian Patent and Trademark Office, and we have six IP offices throughout India. For the northern side, we have Delhi Patent Office. We for the central and western zone, we have Bombay Patent and Trademark Office. For eastern zone, we have Kolkata Patent and Trademark Office, and for south zone, we have Chennai Patent and Trademark Office. So now coming to the question of patents. So when you use the word patents, the definition of patent says that patent is a right granted to an invention for a limited period of time. Now, if we really go by the definition, so basically, if you have an invention, that could be a product or a process. So if you have a product or a process, you can file a patent application for that. So that's the first thing. Now the second question comes: if you have an invention and if you have filed a patent application, what are the rights associated with that patent application? So if you own a patent, so the first right you get is to use that invention, and the second right you get is to exclude others from using that invention. So patent is all about exclusion. So if you have a patent, you can yourself use it, and you can exclude others from using that invention. That's the first thing. So the second question comes like, who grants these sort of rights to an inventor or to an applicant? So the Indian Patent Office grants this certificate stating that this invention is unique and inventive, and this can be used for 20 years, and no one else can use this invention. So if you have that certificate, and if someone is using your invention without your prior permission, you can take legal action against them. So the next question comes that if you have an idea, can you file a patent applications for all sort of inventions? The answer is no. There is some criteria which the inventor needs to follow. The first criteria which the inventor needs to follow is that your invention must be new. If your invention is not unique or new, you cannot file a patent application, and if you're filing it, the patent office will not accept it. That's the first thing. Second, if your invention is unique or new, the second criteria is that your invention should not be obvious to a person skilled in the art. For example, if your invention is obvious and any person without being inventive can reach to the conclusion of your invention, in that case, yes, you can file a patent application, but yes, the patent office will not accept it. That's the second thing. Third criteria which the inventor needs to follow is that the invention must be industrially applicable. So if the invention is not industrially applicable, then the patent will not be accepted, right? And apart from these three important criteria, we have some non-patentability criteria. For example, if your invention is falling under the ambit of that non-patentable criteria, so in that case, patent will not be accepted. For example, if your invention is kind of frivolous, for example, you are claiming something which is against the natural laws. So in that case, you cannot file a patent application. If you're filing it, the patent office will not accept it, obviously. Second is you should not claim something which is against the public order or morality. For example, if you have created a counterfeiting of currency, you have created a mechanism to counterfeit the currency. So in that case, patent will not be accepted. So we have a few other non-patentability criteria, but the few important are these two, and apart from these two, we have 3-4 more. If you are filing a patent application in the computer program in the software area, so you have to be very careful about how you file it. If you are filing a patent application just for the computer code, in that case, patent will not be granted to you. For that, you need to show some hardware manifestation, or you need to show some sort of technical effect that, like for example, what problem exactly the invention is trying to solve through that computer program. So if your computer program is capable enough to be supported by hardware, or capable enough to solve the problem, in that case only the patent can be accepted. Otherwise, for the simple computer program, the patent cannot be accepted. Apart from this, if your invention is relating to an algorithm, so for the algorithm as well, a patent cannot be granted. For that as well, you need to show some sort of hardware manifestation and as well as the technical effect. That's the and apart from these non-patentable criteria, if your invention is an artistic creation, for example, you have created a painting and you want to file a patent application for that artistic creation, then you cannot file. For that, we have a copyright protection in India. And apart from this, if your invention is a presentation of information, simple presentation of information, in that case also you cannot have a patent rights. So these are non-patentable criteria. So apart from this, if your invention is unique and inventive and is not falling under the ambit of non-patentability criteria, in that case, yes, you can file a patent application and your patent will get accepted, and upon acceptance you will have rights associated with that patent, and you can commercially exploit it. You can do whatever you want to do with that invention. You can commercially exploit it. You can franchise that invention. You can lease, for example, like you don't want to transfer rights to other entity, but you want a royalty over that patent. So you can have royalty by means of commercializing that invention through the lease or the franchise model. Now the question really is that, like, who can apply for a patent? That is the very important question we need to understand. See, any inventor claiming to be a true and first inventor can apply for a patent. That's the first thing. Secondly, if that inventor has assigned their rights to any entity, in that case, a patent can be filed by that new entity. Now, for example, if I own a company and I have few employees working with me, and they are using my resources to implement any idea or to implement any research, in that case, I will sign a contract with them, and the patent application, all the IP, all the patents will be filed in the name of my company, and all the employees working with me who are working in that particular invention will be inventors, but my company, since I have executed an agreement with them, will be the applicant. So there is a difference between applicant and an inventor. Applicant is someone who holds 100% rights of your invention, right? So you have to be very careful while assigning your rights. And inventor only have academic rights. They do not hold any commercial rights in that patented invention. So next is the drafting of patent application that we need to understand. See, when we file a patent application, there is a certain SOP which we need to follow. We cannot just write about your invention and file a patent application. You need to follow some guidelines. There is a guideline wherein you need to state what is the field of your invention, what is the problem you are trying to solve, what is the summary of your invention, how it is interconnected with the components, what are the drawings you need to we need to file it, and how these drawings are explanatory enough to explain your invention. You need to also demonstrate the best method of that invention, how these are connected, how it is working, and what are the best method of operating that invention. And apart from this, we need to file claims. We need to draft claims. Claims are very important in a patent application. That actually defines your boundary. For example, if I am claiming A plus B, so I will have protection on A plus B. Now, if someone comes with a new concept of C, I will not have a protection on that A plus B plus C. For that, I need to be smart enough to file claims in a way wherein I can have a protection on A plus B plus C. That is a very important thing. So it is always advisable to use attorney services while drafting or filing a patent application. They can help you in filing your patent application. That's the important thing. The next is like how to file it. If you have drafted a patent application or your attorney has drafted a patent application, the next is how to file it. So you can file a patent application by filling few forms. These forms are explanatory enough. Like they will there is a column in that forms wherein you need to incorporate your name, your nationality, your address, your title of your invention, what will be the address for communication, like how many pages are there in that complete patent application, how many drawings are there, how many claims you are filing, what is the date of that patent application. So everything will be incorporated in those forms, and upon incorporating all this information in those forms, you can file that patent application through your attorney, or you yourself can file it. We need to file that application electronically. So we need to have a e-signature or a DSC of e-mudra to file that patent application. So upon filing that patent application, the patent office will issue an application number. So that application number will be explanatory enough to say that the patent has already been filed. So upon filing the patent application, the patent office will conduct an examination of your patent application and will check whether the invention you are claiming is unique or not, or if it is unique, then it is obvious or not, and it is industrially applicable or not. So after the scrutinization of all these things, the patent office will issue an examination report. The examination report will comprise of few objections pertaining to your invention. For example, if your invention is unique and it is not inventive, then the patent office will cite few documents which are more or less similar to what you are trying to claim. And so after the issuance of the examination report, the applicant or their attorney are required to file a reply within 6 months. So for example, if I can receive an examination report on April 6th, 2024. Then by October 6th, 2024, I am supposed to file a reply to that examination report. So after filing the reply to that examination report, the patent office will recheck it and will conduct a re-examination. And if everything is found if everything is found correct, then the patent office will accept it. Otherwise, they will issue a hearing notice. So now that hearing notice is a last chance for the applicant to demonstrate the invention. Like for example, the applicant will be called electronically through the video conferencing, wherein the applicant will be required to explain the invention, like how it is unique, how it is inventive, and how it is not obvious to what have been cited by the patent office. So after the argument process, the patent office, if it is satisfied, they will accept the patent application and will issue the certificate. And if your invention is not unique and it is not found satisfactory to the patent office, so in that case the patent office can refuse your patent application, or if they want, they can give you a second last chance, wherein they can ask you to revisit the patent office, I mean electronically, and to explain whatever your points are. So after this due process, if your patent is granted, your patent will be granted for 20 years. So during the course of 20 years, you will have certain rights: a right to exclude, right to use, right? So these are the rights associated with a patent application. And during the course of 20 years, you need to pay some fee to the patent office. So if you don't pay that fees, the patent will get seized, and you will not have rights for that patent application. So this is all about patent application. I once again thank you everyone for giving me this kind opportunity to express my views on the protection of IPRs and particularly patents. Thank you.